getting ready to start the second component of the finals rounds of the 2024 National Animal Law Competitions. So we will be, this will be the closing argument component. So all rise, please, for the judges we have. This is now switching from a, in the semifinal round, they played the role of a jury. Now it's switching to more of a bench trial, so they will be asking questions of the competitors. So you may be seated and we will begin.
Good morning, members, judges, your honors. My name is Emily and I am representing the plaintiff, Jordan Almond. This case is about one woman's need for control over nature and her willingness to use cruelty to achieve that control. Her desperation for domination caused extreme injury to an innocent cat's life, which in turn emotionally crippled my client. We can all agree that Sphincter, a harmless and loving companion to Ms. Almond for nearly 14 years, did not deserve to be permanently, physically, and psychologically disfigured by the defendant. My client did not deserve to see her beloved pet mutilated and bloodied after he was trapped. My client did not deserve to pay exorbitant medical fees just to keep him alive and then suffer through the further trauma of his recovery. To make matters even worse, this harm was caused to my client by her neighbor. The defendant, Ms. Mizzou, is Ms. Almond's neighbor, and the two women were even friendly before this fateful day. Our communities, and especially our neighbors, are a critical part of life here in Cosmopolis. If we can't trust our neighbors, it is a dark life indeed.
Wasn't Sphinx's injury really ultimately caused by your client's negligence in failing to control her cat?
No, see, that is one of Ms. Mizzou's main arguments, is placing fault onto my client. But first, it is perfectly legal in Cosmopolis to allow your cat outside. And just because something is legal doesn't mean it's necessarily the best idea. I totally understand that. But she also took precautions. Her yard is fenced in. She rarely lets Sphincter out. He, in fact, had only just recently begun to be let outside because he was just neutered. And she almost always saw him right by her back deck. So she, kept an eye on him, and for the most part, he was there. And as I said earlier, she rarely let him out. And while if she had known that he had wandered to Ms. Mizzou's property before, perhaps she would have, been able to keep him inside if she had known that this trap was being set there and that he might fall prey to it. The defendant did not tell my client until after she trapped and nearly killed.
Okay, could you just address that posting though and how that plays into what you just said?
Yeah,
she
sure.
did warn the neighbors.
Yeah, so my client did see the flyers that the defendant had put up around the neighborhood, but they didn't identify where the trap would be. And they didn't identify that it was Ms. Mizzou who was posting them. And again, Ms. Mizzou and Ms. Almond were pretty friendly before. They'd see each other at Starbucks and things like that. And so they had a kind of rapport where you would assume that if your neighbor was setting a dangerous trap and had seen your cat over at her house before, that she would, directly warn you in the same way that Ms. Mizzou directly warned the Guptas and, put a flyer in their mailbox and went to their door and tried to communicate with them.
But the Guptas had the dog that she was targeting.
Right.
She wanted them to do something about the dog.
Yes.
I think a responsible cat owner, knowing that there were these pamphlets and that somewhere in the neighborhood there was a dangerous trap, and to think it was inapplicable is a little inexplicable.
Mm-hmm. Well, again, my client did not. It was new for her to be letting Sphincter out in the first place, and most of the times that she.
Do we know that? We know the dog was just cat was just neutered, but they'd had the cat for 12 years? or
Yes.
more, so they might have let the cat out until the cat was neutered and then it was recovering. So we
My
really
client
don't know.
did testify that they were just first letting him out for the first time now that he was neutered. They hadn't prior to this.
Well, okay, that's, all right,
Yeah, so
that's,
I completely understand, but again, my client did not want to deprive Sphincter of some time outside, especially because he normally stayed right by the back deck, so it wasn't a huge concern. And while she did see these signs and, you know, made her wonder, she didn't feel like they were applicable to her. And again, you know, letting your cat outside is a pretty normal part of that neighborhood, and there are many other cats in the neighborhood that wander outside and things like that. So,
okay.
Counsel, so is it your position that your client is not at fault at all?
yes.
Okay.
Okay. We're here today because
Hang on a second. Are you saying your client is taking no accountability for what happened?
my client wishes that she had kept Sphincter inside, definitely, because regardless of Miss Mizzou's actions, if she had never started letting Sphincter outside, this wouldn't have happened.
So isn't that accountability right there?
It's not, she wishes that she had changed her actions in the sense that in the same way where if you stay inside your whole life, you're never going to get into a car accident, but that's not necessarily a reasonable thing to expect of people. And I think that she wishes she could embrace the physical and psychological trauma both to Sphincter and herself, and would be willing to do anything to make that happen.
You bring up psychological trauma again, and you talked about in your opening about psychological disfigurement of the cat. So tell me, what was the psychological disfigurement, and how do you know that?
Sure. So we can tell by Sphincter's injuries that he was trying to get out of the trap. And so when he first arrived at the vet clinic, or at the Humane Society, I'm sorry, part of his jaw was missing, as we can also see in the pictures. And
So that's physical.
yes.
Tell me about the psychological.
Yeah, so after he was stabilized, and once he came home, his personality started to change. You know, he started acting differently because of the physical symptoms. For example, he couldn't eat himself for at least 2 weeks, and instead of being able to release saliva, it would pool up in his mouth. He also was unable to bear weight on the leg.
Okay.
That's all physical, that's not
Yes,
psychological.
but that blends into or leads into psychological trauma. He became much quieter. His sweet, sort of bubbly personality changed, and he really lost sort of like the spark for life. And then, you know, in the later incident when his back
Thank you.
pain
You
went-
answered it. Appreciate that. You answered it.
Oh, okay.
Thank you.
Counsel, can we go back to your client's accountability? What is the burden of proof that your client has to prove?
Yeah, it's by preponderance of the evidence. So although it's not a negligible bar, it is a relatively low bar, and we just have to prove that it is more likely than not that the defendant was negligent, which I believe we have here.
So you'd agree with me that your client could take some accountability and still win this case?
Yes, yes.
But that's not your position.
No.
Continue.
So yes, we can actually go right into negligence. So the defendant. So Ms. Mizzou failed to follow the applicable standard of care because she broke the law by using an illegal trap. She also.
Excuse me, is that sort of a per se conclusion? The fact that it was illegal means you don't have to show anything more?
No, so you all have instructed the jury that they can take breaking a state law as, or consider it evidence when they're determining if the defendant was negligent.
Okay, so, but
that's where
something
that would
more
fit
would
in.
be necessary to show that the standard
Yeah,
of, okay.
so we have to show that my client suffered injuries and
No, I understand that, but on the standard of care, that the illegality is sufficient by itself to show that she
I
didn't meet the
believe so,
standard of
yes.
care. All right.
So next,
Without regard to this other statute that deals with being able to kill a dog that is destroying
yes,
wildlife on your property?
yes, that regulation does not permit you to use an illegal method to
But it doesn't really address it, does it?
go. No,
Yeah,
but
okay.
yeah.
All right.
So my client was injured when she, saw Sphincter in this state. She worried for his survival. She had to pay $21,000 initially just to keep him alive. He was at a vet hospital for 4 days, and his status was sort of touch and go.
Could I ask you right there, though? I think the record showed, you tell me, but there was trouble finding where to bring the cat right away.
Yeah.
And they ended up only finding an emergency veterinarian care. So sometimes would that be an issue of the cost there, that it automatically is higher than a usual required cost to do what they did?
So the vets at the Humane Society did say that he needed to go to an emergency vet clinic. So those are that's the group of places that she did call. And so it is what they advised her initially of a type of place to find. So I think that I understand what you're saying.
Counsel, I do have a question for you. You cited $21,000 for vet bills. That's a lot of money. You could probably buy, 2,100 cats at that price? So how do you reconcile your claim for $21,000 against jury instruction 18 that says that in an action for injuries to an animal, the owner may recover the diminished value after cure, so far as the cure was affected, expenses incurred in reasonable attempts to effect a cure, and reasonable compensation for loss of use while under treatment, provided the whole damages don't exceed the original value of the animal. So how do you get past that? How should we get past that?
Yeah, so I believe that jury instruction goes specifically to the damages based on the valuation of the cat, whereas the economic damages in this case, the defendant directly caused by trapping him those $21,000 because his leg was mutilated in the trap, as the trap is meant to do, to a animal's leg. That physical trauma resulted in hypothermia, needing a blood transfusion, a mandibulectomy, all of these things that were necessary for him to survive. And so that goes to the economic damages we're asking for, rather than specifically his valuation and then the change in his value. So I think it can be thought of as two separate, related but separate issues.
Okay.
Okay. So lastly, for negligence, I believe it's pretty clear that Ms. Mizzou's negligence was the proximate cause of the injury, because if she hadn't set the illegal trap in the first place, regardless of whether my client let her cat outside or not, if there wasn't an illegal trap there, these injuries would not have happened.
Well, we get to the same question of if she hadn't let the cat out, they wouldn't have happened either.
Right, but if there was no trap,
No, it's which came first, the chicken or the egg. Okay.
So then we can move on to outrage. So the defendant acted recklessly when she put out this dangerous, cruel trap. Not only that, but not only that she set out this trap for Bogart, but that any animal could have gotten into it. And that's pretty obvious. It wasn't, specially designed just for Bogart. And in fact, Miss Mizzou baited the trap with the same cookies she had previously offered to Sphincter. And although she claims that Sphincter did not have any interest in those cookies, she gave them to him in the context of welcoming him to her yard and petting him and greeting him. So to him, those are associated positively, and her breadcrumb trail of cookies leading up to this trap.
So she says that she just wanted Bogart to be caught.
Right.
Surely she
And-
wasn't aiming at the cat.
Yeah.
No, and my client is not arguing that at all. We believe that it was an accident in the sense that she did not want to capture Sphincter.
Yeah.
But that doesn't matter here because setting a dangerous illegal trap, any animal could get caught in it.
But does that go
and
to
she
the
knew
outrage
that.
intent?
Yeah, so because of transferred intent, it does because even though she intended to trap Bogart with this trap, because it actually harmed Sphincter, there is transferred intent there.
But the transferred intent jury instruction talks about a third person. He's not a person.
Right, so he's property, he's my client's property, and so that transferred intent transfers from essentially the Guptas because they're Bogart's owner to Ms. Almond, who is Sphincter's owner. So Ms. Almond clearly actually suffered serious emotional distress from Ms. Mizzou's action. She again is not claiming that she needed psychiatric care only because of this incident and because of the results of Ms. Mizzou's actions. But that was a big piece in creating a emotional situation for my client where she was less able to handle other tragedies that happened around this time. And just because she did suffer some unrelated tragedies does not take away from the emotional trauma that Ms. Mizzou caused by trapping and nearly killing Sphincter.
Well, can your client recover for the emotional damages for witnessing or dealing with what happened to her cat in our jurisdiction?
So she cannot receive damages for intentional infliction of emotional distress, but there are two ways in which she can. So non-economic damages, as the jury instructions say, mental anguish. If the jury decides that malicious injury and outrage were committed by the defendant, then they can award for mental anguish.
So what is her mental anguish? If she didn't treat, how do we know what her mental anguish is?
If she didn't.
If she didn't go for treatment, I believe you said she didn't go for treatment. How do we know what her mental anguish is?
Yes, so based on her testimony about having PTSD every time she sees him stumble and fall and drool, and then the mental anguish of watching him run up a tree, getting scared, fall, and then have to get the leg amputated, the loss of companionship from her special needs daughter that she's been able to rely on with Sphincter, and now that his personality changed, that's not there. And then the emotional angle also comes in under the valuation of the cat, because the jury instructions do say that they can consider the actual value to the owner if there's not a market value and a replacement value, and they can consider the emotional distress from this issue in part of that valuation of what the cat meant to her.
So
Counsel, just going back to the amputation, are you asking for damages for the cost of the amputation?
Yes, we are, and that's because even though this was at a later date and is, seemingly an unrelated incident, really, if Ms. Mizzou had not set this trap and trapped Sphincter, that wouldn't have happened either, because that incident occurred because Sphincter, now being skittish and scared, wandered out the front door, got spooked, ran up a tree, and then fell out of that tree. I think most cats we know would land on 4 legs and be okay. But he didn't. He landed on that leg that originally was trapped, and it broke and it had to be amputated. So we are asking for that, and we believe that that's reasonable.
So you're saying that Sphincter would not have run out the door, despite the fact that your client left the door open, it's only because of this incident with the trap that
Well-
Sphincter decided to run out?
Well, so my client did leave the door open and she acknowledges that and wishes she hadn't done that. But they had to baby gate the whole house because of the original incident because they had to be so careful now with his movements. And so they believed that the kitchen was baby gated as normal and they must have forgotten to do that and then he wandered out. So it is a combination of factors, but they wouldn't have needed to worry about baby gating him and things like that before Mrs. Sue set this trap and harmed him. Thank you.
All right, coming up, we've got the second competitor in the closing argument finals. This is Tyler Adams.
Good morning, Your Honor. As you know, I'm Tyler Adams. I represent the defendant, Ms. Misu, in this case. And we're here today because of an unfortunate accident that occurred on August 3rd, 2022, where the plaintiff's pet cat Sphincter was caught in a trap in Ms. Misu's backyard. Now, in the lead up to August 3rd, I'd like to remind Your Honor that we heard at trial that my client, Ms. Misu, was focused on one thing only, and that was protecting the Putus. You heard at trial, my client testified extensively about how important these little birds are to her. They live in her backyard, they built their nests back there, and she loves sitting out there and watching them. Because Ms. Misu lives alone, she doesn't have any family in the home, and these little birds are her companions. Her backyard is very important. It's a place of peace and serenity. It's her refuge. And her backyard, in this case, was under bombardment, and harassment, and attack from a neighborhood dog named Bogart. Now, Bogart had been getting into Ms. Misu's yard. He was destroying her private property. He was roading up her flower beds. He was clawing all the bark off of her trees. But most harmful of all to Ms. Misu was that Bogart was hunting and killing these birds that meant so much to her. So Ms. Misu finally just said, this has got to stop. It was tormenting her. So she tried her best to handle it as directly as possible. She talked to Bogart's owners, the Guptas. She tried to. She left a note on their door and just said, hey guys, can you please get a hold of your dog and stop this? And that didn't work, Your Honor. No response, no help from the Guptas.
So we've read the record. We're aware of the facts.
Yes, Your Honor.
Why does your client believe it's up to her to protect these birds? Does she own these birds?
So, Your Honor, my client does not own these birds. There's two things at play here. First is my client's general right to enjoy the use of her own private property from invasion. And second is, under Utopia law, these birds were building their nests, they were raising young, and even though they're wildlife and they're not domestic pets of my client, she was still entitled under Utopia law to intervene in Bogart's hunting and killing of these birds.
Counsel,
Yes.
did your client actually ever see Bogart kill these birds?
Your
Did she
Honor,
ever catch him in the act?
She did not see Bogart in the act. However, the Putus are nocturnal. So at the time that Bogart was actually hunting and killing the birds, my client was in bed and didn't see him, but she heard him back there digging around, barking, recognized his sounds, and she heard these birds screaming. And then when she went out in the morning, there were dead birds and feathers and slightly less birds, over the course of time as he was killing them.
So I just want to draw your attention to instruction number 13. You aware that the language says that your client wouldn't be able to actually kill Bogart unless he was found running at large or found chasing, biting, or injuring other animals? Wouldn't you agree with me that wouldn't give her the right to kill Bogart unless she actually found him in the act of doing so?
Your Honor, I'm willing to concede that point. At the end of the day, whether or not she was entitled to or not, Ms. Misu does not wish harm upon any animal. And even though Bogart was tormenting her so viciously, she went about her attempts to stop him as far as to minimize the harm to Bogart to the best of her ability.
So wouldn't you
I'm sorry.
wouldn't you agree that she used an illegal trap and then also tried to utilize a law that she didn't have a right to use, which is ultimately what, injured Sphinx at the end of the day?
Your Honor, a couple of things on the point of the trap I'm happy to address. Number one, the plaintiff in this case has not sufficiently pled a case for negligence per se for a number of reasons. Second of all, as Your Honor is aware, there was a separate criminal action with my client, and the other prong as far as the trap use goes, whether it's negligence per se or whether it's the existence of an Alford plea in that criminal case, neither of those have impact on the outcome of this bench trial, and I'm happy to.
Are you saying it's irrelevant that she used an illegal trap?
I'm saying under the standards of the claims that the plaintiff in this case has brought, the fact that my client set the trap that she set or that she pled an Alford plea in subsequent to setting that trap are not dispositive of negligence or guilt or liability in this case.
Not dispositive, but surely relevant, at the least.
Certainly, yes. Your Honor is welcome to consider that in the context of all the evidence in this case as well.
Counsel, I'm still stuck on your comment that she didn't harbor any animosity toward animals. How do you reconcile that with her drowning squirrels and trying to discipline birds behaving badly?
Your Honor, it's not illegal to, again, defend private property from nuisance animals. There's been no claims brought on behalf of any animals that my client lawfully disposed of in the defense of her private property. There's been no evidence given to suggest that my client was hunting these wild animals because of malicious intent versus just property maintenance and what she was entitled to do under Utopia law.
So drowning is just property maintenance. There's no malice aforethought in that type of activity.
No, Your Honor. My client had no malice towards those squirrels.
I would hardly call her an animal lover on the basis of the record we have. You just said she was an animal lover.
She did love animals, Your Honor.
But she just drowned them and tied them up, and if they were a nuisance.
Yes, Your Honor.
Okay.
The trap that she used for the squirrels, couldn't she have just trapped them and then released them somewhere else instead of drowning them?
Your Honor, I suppose we could play, I am only familiar in representing Ms. Misu in the defense of the claims of negligence against Ms. Amond related to sphincter. And I'm just not sure, how to.
So are you really getting at the preponderance standard here, that she can have some bad qualities and yet not reaching the point of, I think what you're saying, malice, which is sort of what we're getting at, because a lot of her conduct is pretty scary from the record.
Exactly, Your Honor. The plaintiff has the burden in bringing this case of the preponderance, considering all of the evidence, and for a number of reasons, any flaws that my client has or any attempts that maybe could have gone about in a better way don't push the needle as to more true than not true that my client negligently hurt sphincter or committed any of the specific intent crimes of maliciousness.
If you lived next to this woman, would you let your cat out?
Your Honor, if I lived next to this woman and if I owned a cat, I would make sure that I was properly caring for my cat and making sure that they weren't in danger.
So did your client did she have any responsibility for what happened?
Your Honor, no, she does not. Not in this
Nothing.
case, not under Utopia law. And furthermore, Your Honor, on that point, even if the court were to find some degree of negligence or some degree of proximate cause that Ms. Misu contributed to in this case, the plaintiff is nevertheless entitled to no damages. And so I'm happy to move to that point momentarily.
Well, I just want to understand why you can't find anything that your client may have done wrong, especially using an illegal trap. You're not willing to even concede that point, that
No,
she
I'm not,
contributed?
Your Honor.
Is that because of that evidence we have about what she claims her lawyer told her? I'm not
Absolutely.
understanding,
If we-
you haven't addressed that point.
Absolutely, Your Honor. So I'll move to that now.
Wait, I'm sorry. She knew it was illegal. She'd been arrested previously, as I understand it, before she consulted the lawyer. So she trusted her lawyer rather than the fact that she'd been arrested for using the same trap?
Yes, Your Honor, and that goes back to the point I was making a moment ago about the use of the trap itself not being sufficient alone, standing on its own, to prove negligence in this case.
But that's not what we're talking about. We're talking
Your Honor.
about, was there some fault on her part?
In this case,
Some negligence on her part, if you will.
No.
And why not?
because the plaintiff hasn't pled negligence per se to say that the setting of the trap on its own constitutes fault on its own
Yeah,
without
okay.
anything else.
All right.
And as Your Honor mentioned, my client had been arrested. She had been accused of a misdemeanor violation of the statute pertaining to this type of trap. But because she had been given this advice by an attorney after fully disclosing the material facts in this case,
But did she?
Did-
How do we know that?
Yeah.
I mean, we don't
I-
have the lawyer's testimony, and we just kind of have her self-serving, maybe?
We don't know
Help us out
if
with
she's
how
told.
important that is to your case.
Your Honor, even without anything involving Mr. Meeker and his poor advice, my client still would prevail in this case because the plaintiff cannot meet the burden of proof on the elements of all of her claims and cannot prove damages.
But that's a different point. You told us that you were not conceding any negligence on the part or any causation of this accident on the part of your client. And I think that's what we were getting at.
So, Your Honor, certainly Mr. Meeker's bad advice contributes to the full body of evidence in this case of whether my client had a duty, whether she breached that duty by putting the trap down, and whether she was negligent in this case, or a proximate cause if what she did because of relying on the advice of counsel. The question as to whether, how can we believe this? I was just responding that even if the court did not choose to believe Ms. Misu's testimony about that full disclosure of facts, about that conversation, and about that good faith reliance, even taking that, the plaintiff still has not sufficiently pled her claims and should not prevail in this case. Now, importantly as well, Ms. Misu, before she put the trap down to capture Bogart, after speaking to her lawyer, went up and down Merriweather Lane and put flyers in all the mailboxes, letting all of her neighbors know that this trap was being put and to keep their animals inside to prevent inadvertent capture or injury.
So, counsel, is it your client's position that if she puts signs up, it's okay to just kill people's pets?
No, Your Honor, that's not the position at all. The position is that relating to proximate cause and negligence, this sign and the fact that the plaintiff testified at trial to seeing this sign, to understanding it, and to knowing that in the preceding months there had been a number of incidents with animals killing domestic pets in the area, that the plaintiff had some understanding and notice that there was a danger to her cat in that neighborhood and still chose to let her cat roam, get into Miss Misu's backyard, and ultimately end up trapped.
But the sign did not say, give the address of where the trap was going to be, did it?
No, Your Honor, it did not.
Which is something of an omission, yes?
Well, Your Honor, as well as posting these signs, Miss Misu also posted in the Nextdoor page of her neighborhood, which is tied, to a name. It's kind of like a Facebook message board type thing. And so even though her address and contact information weren't on the signs that she physically put in mailboxes.
There were? There were? Her address
Were
was?
not.
Yeah,
Were
okay,
not.
I'm sorry. All right, yeah.
She communicated through other mediums to the neighbors as well that this was happening, to be thorough, and her information was tied to those messages that went out to the neighbors. So
You
the-
mean her
the neighbor-
contact, her address was tied to what was going on? Is that what you're saying?
Your Honor, I haven't
You're not really
discussed
sure.
if she exactly put her full address
Yeah,
on there, but
all right.
certainly
So
her
we just-
name was
Okay.
attributed to those
Yeah.
electronic communications, and the neighbors in her street would have known that she was the one who published it.
So you're saying these signs acted like a waiver of liability. If your client wanted to change the speed limit in front of her house to protect these birds, let's say, would she be allowed to do that?
Absolutely not, Your Honor. And it goes back to my original point about the first thing that the plaintiff has to establish for the negligence claim is that my client owed a legal duty to sphincter beyond that of just the reasonable person's standard of care. And what this is meant to show is that, again, my client owed no duty because she was defending her own private property. And even though there is the provision and the carve out under Utopia law that cats and pigeons cannot be considered trespassers, shielding the plaintiff from liability for her cat trespassing onto the private property does not create a legal duty of my client to protect or prevent harm to cats that come onto her property.
So the cat, are you saying the cat trespassed?
I'm saying the cat was not an invitee or a licensee or otherwise welcome on her property in her fenced backyard.
Were the birds invitees?
The birds were wild animals. And so the point that I was just making, Your Honor, as far as to the point of the speed limit that initiated the conversation. The speed limit wouldn't apply because obviously she can't change the speed limit. That relates to public safety and multiple things that are not within her specific scope of domain of her private property, and that's how this.
So let's stop there because I'm getting stuck on just how far you get to go to protect your property and
Yes, Your Honor.
how you've said there's no malicious intent, which of course, from the instructions, we could then trigger emotional non-economic damages for the plaintiff.
Yes, Your Honor.
In addition, you haven't allowed the economic damages, I don't think.
That's correct, Your Honor, and I'm happy to touch on that. So
I mean, why isn't it beyond the pale of decency what you did?
Your Honor, for a number of reasons. Number one, for the claim of outrage, the plaintiff has the burden of proving by preponderance of the evidence that my client was intentionally or recklessly caused emotional harm to the plaintiff. Now, as Your Honor agreed at court and during trial, there was clearly no intent. And so what the plaintiff is left with is reckless infliction of emotional distress. And for a number of reasons, the plaintiff cannot qualify as an emotional distress plaintiff under longstanding tort law, primarily because she doesn't meet the three elements for reckless infliction of emotional distress. She was not present on the scene when Sphincter was actually accidentally trapped. She had no contemporaneous sensory observation of his suffering or his pain. And finally, Your Honor, Sphincter is as a domestic pet, and although he may be considered a member of their family, he's not something like a human child, which is consistent, again, with standard case law, Thing versus Lechusa, et cetera. And then even in the context of negligent injury to pets, there was a case in the past couple of years, Thompson versus Lead Animal Shelter, where very similar circumstances, and the court found that even something that may be very distressing to someone who very much loves their pets does not entitle them to plead emotional distress damages for reckless injury when they're not present.
Well, I mean, you said not present. No, she wasn't present when the cat walked into the trap. And I gather she didn't see the cat until the cat had been taken out of the trap. But the cat was in distress, no question about it, and stayed in distress for quite a long time.
Yes, Your Honor.
And plaintiff witnessed all of that.
Your Honor, specific to the ability to plead emotional distress damages, the fact that the cat had some later emotional distress.
No, this was all from the same. This was all from being maimed by the trap. I mean, this wasn't something that coincidentally happened afterwards.
Yes, Your Honor, but for the purposes of pleading emotional distress damages for reckless infliction, the plaintiff has to have been in that zone of danger and witnessed contemporaneously that injury to successfully plead for emotional distress damages. Any emotional distress that she suffered in the aftermath or aftercare is outside the scope of foreseeability of my client to prevent. My client can't be held responsible for recklessly inflicting.
The client could not have foreseen that once the cat, was grievously wounded, that it would not be distressing to the owner of the cat?
That's correct, Your Honor.
Couldn't have foreseen that. All right.
But counsel, didn't the trial judge hear this contemporaneity argument and basically ascribe it simply to going to the weight of the evidence, didn't actually strike the claim on that basis? And also, even though plaintiff wasn't present at the time of the tort producing event, wasn't she there and in order to see the aftermath before a substantial change in the condition of the victim of that action?
Sorry, Your Honor. I didn't want to interrupt you. I'm like slightly hard of hearing, so I couldn't quite hear
Oh, I'm
your
sorry.
question. I'm sorry.
Sorry about
I
that.
heard like trial judge didn't plead it, and I know we're
Right.
running out of time. Sorry.
No problem. Well, at page 6 of the transcript, the trial judge did consider the contemporaneity argument, and as I read it, basically rejected any attempt to dismiss out the claim on that basis, saying it instead goes to the weight of the evidence. So wouldn't you still argue, I basically would want to know, isn't there still some degree of outrageousness of the behavior of your client in using this illegal trap, even if the nuisance abatement instruction here provides her some leeway in removing that threat?
Yes, briefly, Your Honor, I'll address that. There is no proof of outrageous behavior that is utterly intolerable in civilized society. My client had a legitimate purpose for setting that trap. She was trying to protect her own property. She was trying to catch a dog that was invading her property. She took multiple steps to reduce the risk of injury to Sphincter. And again, she relied on the law as she read it and as it was communicated to her by her attorney at the time. And briefly, in my final moments, Your Honor, I'd like to again reiterate that even if the court were to find that my client was in some degree negligent or in some degree a proximate cause of Sphincter's injuries, the plaintiff has nevertheless insufficiently proven any of her damages brought in this case. Sphincter was not removed from her. He didn't pass away, thank God. And he's still a pet in the Amon household and therefore has no market or replacement value because he is still a part of their pets. His purchase price was $0. His value at the time was similarly $0. The plaintiff hasn't brought any sufficient evidence of her damages of these vet bills or their reasonableness. And again, for the reasons we've discussed at length, Your Honor, the plaintiff is not entitled to non-economic damages either. Thank you.
Thank you.
All right, coming up next, we've got our third contestant in the closing argument of the final round. This is Mason Liddell.
Your Honors, my name is Mason Liddell, and I represent the defendant in this case. Now, over the next 20 minutes, I intend to address the 4 claims that the plaintiff has brought against my client, Ms. Tiramisu. I'm going to argue that my client was not negligent because of how high a standard of care she presented in this case. And I'm going to argue that if she was negligent, then the Guptas, Ms. Amon, and Mr. Meeker all share in liability here. Second, I will argue that Tira is not liable for outrage because her actions in this case were neither intentional nor reckless. And on top of this, she acted well within acceptable societal bounds. Third, I will argue that Tira did not maliciously injure Sphincter because she was not malicious in this case. And fourth, I will argue that Tira is not liable for conversion because she had a justification for the acts that she took here, and the acts that she did not take anyone's property. My client, Tiramisu, genuinely cared for Sphincter. And as I go through the facts here, I want to heavily emphasize that. Her actions and words show this time and time again. And many of these torts, as you know, require that Tira did not care about Sphincter or about Ms. Amon or about society's rules and laws. But none of that's true. Tira did care tremendously. I ask that you keep this in mind as I go through the questions. So I'd like to start with negligence. The first question, did Ms. Amon prove that Tira was negligent in this case? And the answer is no. As you know, negligence requires that 3 elements be satisfied. That Tira failed to exercise the requisite standard of care.
So, Counselor, we're familiar with the elements of negligence. Does your client have any negligence here? Has your client done anything wrong or in any way contributed to the suffering here of the plaintiff?
With regards to those elements, I do admit we cannot deny that there was an injury here. Certainly, Sphincter was injured, Ms. Amon was upset and had to pay money.
Well, that's an easy one to admit to, but do you admit to any liability on the part of your client?
We do not admit to liability because of the standard of care that was satisfied here. Tira was not negligent because her standard of care was quite high. She provided a lot of care in the events that led up to this case.
And is that mostly, remember, preponderance standard, right? So I'm weighing the plaintiff's conduct versus your client's conduct. So it seems like there's harm done on both sides. And you're arguing to me that your client goes with no harms, or I'm not understanding what your answer was to the last question.
Your Honor, we definitely agree that there was a harm here. Where we disagree is that the standard of care required for Tira to have been negligent is met. We do not believe that Tira was negligent because of the acts that she took leading up to this case, where she would warn her neighbors in those 3 different ways. For example, setting up a sign that says explicitly.
So good enough.
Good enough is maybe how,
Okay.
good enough to satisfy
Okay.
negligence in
So-
this case.
But counsel, wouldn't you agree that your client used an illegal trap?
With regards to the illegal trap, I think that there are a couple of issues that haven't been hashed out in this court yet. For example, there's no case law on the interaction between RCU 16-08020 and the other law, 77-15-19-4, Section 3. There's no interaction there. There's also no conversation that we had yet in this court about nuisance abatement, which is also in the jury instructions and would very realistically allow my client to set this trap. On top of this, there was no notice about the illegality, or at least nothing quite certain, because she hadn't been convicted at this point yet. And on top of all of this—
But she'd been arrested. She clearly knew there was a statute, ordinance, whatever it was, that said this kind of trap was illegal. She knew that.
Yes, Your Honor, that statute does exist.
And
Where
she knew it existed.
Where I would push back is that she didn't know about the details of this interaction, in part relying on an advice of counsel defense.
The details of what interaction?
The interaction of this statute that bars the trap, as well as the nuisance abatement laws and the 16-08020 law that exists. And that hasn't been answered in this courtroom yet. And as I would say, that is the plaintiff's responsibility to demonstrate that this law does carry weight in this context. And that is an open question that hasn't been settled here.
So counsel, is your client claiming ignorance of the law?
My client isn't claiming ignorance of the law as a defense. Instead, I think as a defense, we're relying on advice of counsel, because she gave Mr. Jim Jack Meeker, her lawyer before me, she gave him as much information as she could possibly provide in this.
Or if she just wanted.
We
the
don't
lawyer to
know.
know. I'm a little concerned about that. He didn't testify, or she didn't testify, the lawyer. So we don't really have a sense of, yeah, she told me everything. Or was it selective words? So how do I weigh the importance of the advice of the lawyer, she claims?
I think that in this moment, it's important to return back to the evidentiary standard, preponderance of the evidence. It may be true that we haven't had the lawyer here to testify what happened, but we did have Tira here testifying that she said everything that was necessary in this moment. And on top of this, it is still the plaintiff's responsibility to show otherwise.
Counsel, I want to go back to your point here about the law being unsettled. Jury instruction 12 says it is unlawful to use or authorize the use of any steel-jawed, leg-hold trap, and so forth. Unlawful is unlawful, isn't it? And are you arguing preemption? Somehow that the justifiable canicide statute endorses killing by a means that would be otherwise unlawful? And so that's my first question. The other question is nuisance abatement you mentioned. Doesn't it require, under Utopia law, that the abatement occur without a breach of the peace or doing unnecessary injury? And wouldn't using an illegal trap constitute both?
Your Honor, responding to the second question first.
Thank you.
It does not necessarily, it's not per se a breach of the peace to use an illegal trap like Tira did in this context. Where she set this trap, it was on her own private property in a fenced-in backyard, and the only intruders that she knew she would get were essentially Bogart and wild animals. It's not breaching the peace to set a trap in a context like that. And it's not breaching the peace to try and capture Bogart either. She selected this trap deliberately because she believed it would cause minimal harm to Bogart. And if anything, I would say this is maybe more of a defense of the peace. If we recall the context of what Bogart was doing throughout this case, where he was killing patoos, birds, voles, squirrels, other small animals. And Tira testified explicitly it was the screams of the patoos that made her want to take action in this moment. And she tried other efforts to keep Bogart away. She contacted the Guptas, and then she had set up those sonic warnings to keep Bogart away. She tried water, she tried visual deterrence. She tried every reasonable step that might deter him from wreaking havoc across this neighborhood. And at no point did any of them successfully work. And that's the reason that she ultimately moved on to use this trap. Now, I believe that my client has not been negligent in this case for those reasons, because as I discussed, she went through all of these steps. This is a high standard of care that she has exercised throughout this case because of how many people she contacted, how many times she tried to do it, with printing signs that warned people of exactly what was happening.
Well, why didn't your client reach out to the courts if she wasn't getting help any other way?
She may not have reached out to the courts, but she did reach out to other proper authorities. She contacted City Animal Control and tried to get them to step in and prevent Bogart from going around wreaking havoc. I can't speak personally to why she didn't reach out to the courts, but I can say that she did not try to handle this entirely by herself. She did reach out to the Guptas, asking them to take action, and she did reach out to the city, asking the city to take action. And the city did, for what it's worth. It's just that they couldn't make contact with the Guptas either. The Guptas were acting illegally. There's a statute that requires that they keep a dangerous dog like Bogart indoors, and they refused to do so in this moment. And for that reason, they would be negligent. They would carry liability as well.
The notion that she intended to do minimal harm, I know that's what she said. On the other hand, this dog was, among other things, killing squirrels, which was apparently one of the things that she did not like. But she herself killed squirrels, presumably not the same identical squirrels, but squirrels that were in her yard. And she caught them in a humane trap and proceeded to kill them. I'm just not sure that minimal harm was very high up on her objective here. I mean, basically, she wanted to get the dog. And she had to have known there would be severe pain attached at a minimum, because that's what the cat trap's all about.
Your Honor, I would return to the evidentiary standard and the burden of proof here being on the plaintiff. We have my client testifying on the record saying that she believed this trap would cause minimal harm. We don't have pushback from Ms. Amon, from the plaintiff, demonstrating that it would cause great harm or that it would cause great suffering. And with regards to the squirrels, I can't defend my client's judgment in that moment. I personally might disagree, but this is a subjective standard. Malice is about what she thought, what she believed. And again, we have her on the record saying that she bought a trap that was humane, and it advertises itself as humane as well. And then she did drown the squirrels. Again, I won't defend.
Well, if you're not gonna, okay, so what if you're saying no, then emotional distress damages, right? That she would owe to the plaintiff. What about the economic damages? Like the vet bills and that kind of cost?
With regard to those costs, I think that there are two important things to highlight. That would be, one, the way that the value is measured here. This is market value, then replacement value, then intrinsic value. And the default is market. It says in the jury instructions that that is essentially assumed. And for this moment, we know that that's comparatively small because there's the limitation on repair costs. Repair costs cannot exceed the original value of the animal as measured by that market value. So while I deny that my client is liable for what she has been accused of here, I would say even if you find that she is liable, there should be dramatic limitations on the recovery for those vet bills. Because my client, because Miss Amond does not have any reason that it wouldn't be measured by market value. This should be restrained by how much the average person, a normal consumer, would pay a normal seller for a pet like Sphincter, an approximately 14-year-old pet, as is how market damages would calculate.
So is a 14-year-old pet worth less or worth more to the pet owner?
I'm not sure that I have a good answer for you at the moment. I think that this would just be a question of the market. If we're looking towards market value, that's something that could be solved at a pet store, or maybe at a humane society someplace where they are selling or adopting out these animals. This question of intrinsic value is something that would come after replacement value, and only then do we start asking the question about how dearly the Miss Amond held Sphincter throughout this case.
Well, you may want to address that in case we get there. So is there a special value that Sphincter has?
I believe that Sphincter does have a real value to Miss Amond. I believe that Sphincter is genuinely cared about throughout the entirety of the community. I mean, people know him. He says hi to them. But I'll also say there is, unfortunately, a diminished value because of the comparatively smaller amount of time they have left together. The jury instructions say that you can account for that lack of companion time together when calculating value. And I can't speak to how long Sphincter might have lived or might continue to live, but I can say at 14 years old, it's going to be a considerably smaller amount of time, a considerably shorter amount of time than it otherwise would have been.
Counsel, even if I were to concede that people with outdoor cats probably commit them to a shorter life expectancy by their own actions, aren't you begging the question here? I mean, where can I go and find a 14-year-old neutered, unpapered cat that somebody picked up for free in a box outside a department store?
Your Honor, some of those considerations are just factors. I mean, we don't have to look exactly towards a one-for-one comparison of finding Sphincter again. The question of finding him as a kitten in a box for free, that's something that would certainly be considered in market value calculations, but the jury instructions are quite clear too, but that's not dispositive. That will make sure that you think about it, but it doesn't actually control here. And I believe that would be the appropriate response. So you should simply take it into consideration, but it doesn't need to be the end-all be-all.
Counsel.
I'm sorry. What about the vet bills? All of them? If we find that the petitioner would be entitled to that as economic damages?
Your Honor, in that case, I would return to jury instruction 18, which provides the instructions on the repair price not to exceed the original value.
Okay.
Counsel, going back to your client's culpability, you're saying your client is not culpable at all? Is that your position?
Our position is that my client is not culpable of all four of the charges.
Okay. And how does that come, how do you justify in jury instruction number 13 with the fact that your client never actually saw Bogart kill any of the POTUs? Would you agree with me that under our law that in order for it to be justified canicide, she would actually need to see it occur or essentially interrupt the killing of the POTUs by Bogart? Did your client ever do that?
Your Honor, to my knowledge, my client did not ever interrupt this event, but we do know that this is Bogart because there's more than just the POTUs. There's also the squirrels, there's the bark being stripped off of the trees, there's the gardening. It might not be Bogart killing the POTUs, although that would still be for the plaintiff to prove in this moment. Where my client put forward, I would say, convincing evidence. There's not really a lot of other animals that could cause this level of destruction besides a large dog. And though there was a large dog 6 months ago, it seems Bogart is the primary threat at this time in the neighborhood.
But what I'm telling you is under our law, she cannot be justified to kill Bogart, especially by using a trap, unless she actually interrupts the act of him killing an animal, whether it's a POTU or whatever. Wouldn't you agree with me that our law says that she can't do that unless she actually sees the act occurring?
Your Honor, I would have to review the law again to remind myself of the exact details of the phrasing, but I would also say there isn't testimony in this case that my client intended to kill Bogart. She was under the misimpression due to Mr. Jim Jack Meager that RCU 1608020 would allow her to capture Bogart, and she did not know that or she may not have known, again, it would be the plaintiff's responsibility to prove it. She did not know that there was the second half of the law, one that might have required her to actually wash Mr. Kerr in order to justify a swift canicide. And she simply did not have this nuanced understanding of the law in this case because of the actions of Mr. Jim Jack Meager.
Wait, we have no idea what went on with her attorney. She said, I told him everything. We don't know if she'd ever even heard of that law or if they discussed it. We don't know anything.
Your Honor, my client did testify that they discussed this law specifically. I, of course, cannot say I was not there personally myself, but again, this is something that has no countervailing evidence. My client did say, this is the law that we discussed, this is what he justified to me and how he justified it. And with that on the record, it's essentially all we have to rely on.
Okay. Well.
Now, I would also say that if we choose to talk about liability, I think it's important to talk about how Ms. Amon, how the Guptas, and how Mr. Jim Jack Meager contributed to the liability for all of these torts. All three of them took discrete, separate actions that led up to the events in this case. And I do not believe, for that reason, I do not believe that we should allow Ms. Amon to profit unjustly on the difficulties that she helped incur, causing Sphincter to need an amputation, breaking a leg, and incurring over $7,000 more in vet bills. This is the responsibility of Ms. Amon in no small part. Thank you for your time.
All right, coming up next, we have our final competitor in the closing argument component of the 2024 National Animal Law Competition Finals. This is Hunter Lindsay.
Good morning, Your Honors. My name is Hunter Lindsay, competitor 471, representing the plaintiff in today's case, Jordan Amon. Now, before I begin my argument, I wanted to discuss the slides we've been seeing today. They are originally more appropriate for the jury portion of this proceeding under the local rules of this jurisdiction. And so at times when there are slides that were more appropriate for a jury hearing than a bench trial, I may just skip over those for the sake of brevity and just for the court's time. Ms. Amon has brought several claims today for malicious injury to a pet, negligence, and the torts of conversion and the tort of outrage. Today, I will be focusing my argument on the first, negligence and malicious injury to a pet. During this bench trial, we have heard sufficient evidence brought by the plaintiff to show that by a preponderance of the evidence, that on August 3rd, 2022, the defendant, Tiramisu, committed negligence and malicious injury to a pet. Accordingly, this court should find in Ms. Amon's favor in order damages that we will discuss. But before I begin the body of my argument, I want to walk through exactly what the defendant, Tiramisu, had to do every morning from 2021 to 2023 to set up the trap. First, she would have compressed the springs of this trap in order to hold the kinetic energy needed for it to act. Then she would lock the trap. And then she would open the jaws of this trap, set up the trigger using this specific notch so that when the target of this trap stepped inside, it would violently snap and capture and immobilize. Now, the first claim I'm going to talk about is negligence. And there are four elements here that we all know have been shown in the evidence today: duty, breach of duty, causation, and harm. To begin with duty, there's the general duty imposed by our laws on everyone a responsibility to act reasonably, or in other words, to act as a reasonable person would under the circumstances presented to the defendant in any applicable case.
Counsel, what is your client's duty to her pet and to her neighbor regarding sphincter?
The same duty that all animal owners need to have for their pets is to exercise reasonable care and due caution in protecting their pet and making sure that pet is safe, abide by Cosmopolis and Utopia animal cruelty laws. But that duty was upheld by the plaintiff, George.
But counsel, wouldn't you agree that your client saw the warnings, potentially the social media posts, and had notice that this trap was going to be set? Wouldn't you agree with me that that would not hold up her duty to be responsible to her pet?
Respectfully, Judge Legier, I would not. That sign was not an effective warning, and in fact doesn't say what the trap would be. It doesn't say where the trap would be. It doesn't say how long that trap would be there. The defendant had a duty to, with this kind of dangerous trap that could have injured anyone wandering over the property, to limit the danger it would cause.
Well, I mean, they weren't the best notice in the world, I would agree with you, but it certainly said to avoid injury or death, keep your pet inside, words to that effect. So it was made clear that this was a trap that could hurt and potentially kill. I think that was in the notice. Didn't give an address.
Well, the specific warning does not indicate that the severity of this trap could cause death. It simply says to avoid inadvertent capture or injury.
Well,
And yet, it was in fact a quite understatement of the threat this trap posed. When Sphinx the cat triggered this trap, he would have died if he had not received life-saving veterinary care. So the defendant, using such a hazard, a dangerous trap, had a heightened duty to be specific in her warnings. And she wasn't, because that's a severe danger. The duty has been established in this case that Ms. Amon was owed a duty by the defendant to exercise reasonable care in limiting the danger the defendant's trap would cause. So the next element here is breach of duty, which is simply failing to uphold the duty you owed, failing to act as a reasonable person under the circumstances. And the defendant owed Ms. Amon a duty to take reasonable steps to limit the danger of her trap. And to go to your question, Judge Coleman, I am sure that the defense will argue when they make, after I sit down, that she only owed a duty to warn, and that the warning was effective. We heard testimony today to that effect from the defendant herself. She was asked, did you warn the neighborhood you were trapping? And she responded, yes. But as I said earlier, these warnings were too vague to be effective, and were certainly too vague to be a valid defense to the claims the plaintiff has brought today. Signs didn't say where the trap was. Signs didn't say what the trap was. Signs didn't say who owned the trap. The signs didn't adequately warn anyone of anything.
So it didn't count for anything. Would have been the same from a legal perspective if she hadn't done anything at all. She just set the trap and not told anybody.
I wouldn't go so far to say it's equivalent to nothing at all. It can certainly
So that
maybe
has
go
some effect.
to a degree of mitigation for damages purposes, but it is certainly not enough to eliminate the unreasonableness of the defendant's conduct. Because not only was this trap set out and warned ineffectively, it was baited with food that could have attracted several animals, not just Bogart the dog. There was not a limitation in the kind of
Well,
bait.
was there a limitation? We had some testimony from the defendant that, about those cookies, that she went to the trouble to say, well, I know that the plaintiff's cat didn't like those cookies. So was that a warning or a mitigation, in other words, that mattered a lot to make even the defendant feel she didn't have to worry about her neighbor's cat getting near there?
I don't think Ms. Amon's testimony necessarily can be stretched to say that she switched to Hamantash and cookies for the purpose of using a food that would not attract Sphinx. I don't think the testimony supports that inference. Instead, I think the testimony supports the inference that when a person baits their trap with food, peanut butter covered carrots, live finches, birds, and cookies, that they're increasing the risk that that trap is going to lure an animal that the defendant isn't intending to lure.
Counsel, did your client letting a 14-year-old cat outside who hadn't been outside for the testimony is for probably 14 years, did she have any liability here for what happened to the cat? Any responsibility?
Well, as I stated earlier, of course, Ms. Amon has a responsibility to exercise due care in protecting her cat and to abide by the animal neglect laws in Cosmopolis and Utopia. However, the evidence, I don't think, supports the idea that by letting this cat out, because there was a further testimony that the cat would wander outside, sometimes yes under supervision, but Sphinx was known in the neighborhood to sometimes lay out on the sidewalk, and even had visited Miss Massue several times, and Miss Massue had fed Sphinx the cat cream and tried to feed those ham and hash and cookies.
So because it wasn't the first time the cat got out, that might absolve your client of any responsibility?
Well, I don't think it's necessarily the quantity of times that got out that may meet or fail to meet the reasonableness standard. I think the fact of the matter is, it's not a reasonably foreseeable consequence of letting your cat out, that this cat is going to wander into a baited trap and lose their leg and a significant amount of their jaw and mandible.
But didn't it make any difference that there were those warnings, which were not perfect, but there were warnings that, keep your animal inside because could have injury because I'm going after a dog with a trap?
Well, Your Honor, placing one sign out, because the evidence in this case shows that the defendant only did one sign over several telephone calls, yes, but only one issuance of warning over the course of 2 years. There is no indication that anyone would believe those signs are still in effect after 2 years of leaving a trap out. It's not as though neighbors could look into the backyard of Miss Massue and check. They had to simply presume that a warning that was taped onto a telephone pole for 2 years was still in effect.
It was 2 years previous that those were put up? Is that clear?
Yes, Your Honor, there was indication in pages 14 of the trial record in Exhibit 1 that the defendant purchased this trap in 2021 and then sent out warnings subsequently to the neighborhood about warning the trap. We saw that question earlier. And then, of course, Sphinx was injured in 2023. So the evidence here does show that for at least 2 years or sometime within that 2-year period, there was only one issuance of warnings. And that's not sufficient to meet a reasonable standard under our laws.
Okay, I didn't read it that way, but I'll grant you it's vague. It would be, after 2 years, you couldn't see the postings anymore. That would be pretty clear. But she said, put something in everybody's mailbox. And you think that was 2 years ago?
Again, regardless of
We don't really know.
time period, recency of that issuance of the mailbox warning, there's indication that only one such mailbox warning was issued within a 2-year period that the hazard still existed. And so this, it prevents Miss Sue's conduct from going into egregious or reckless, but it certainly doesn't make her conduct rise above the standard of reasonableness. It still renders it negligent. And then so putting a...
If we get that far, can you move on to then what are you saying about the defendant's conduct? In order for you to get the damages you want for non-economic damages?
Well, the defendant's conduct on August 3rd, 2023 was unreasonable, and the duty she owed to Jordan Amon was breached. And as a result of that breach, Ms. Amon suffered financial harm through veterinary bills and suffered emotional harm through the considerable stress she incurred watching her cat suffer and not be able to walk the same way it used to. We had evidence, specifically testimony from Ms. Amon, that she has PTSD triggers. And but for the defendant's trap and placing that trap and leaving it out for 2 years, that PTSD trigger would not exist and the cat would not have suffered the injuries it suffered.
But counsel didn't.
Aside from your client's testimony, do we have any proof of a diagnosis of PTSD?
No, Your Honor, but regardless, non-economic damages do not require a specific diagnosis of PTSD. The fact of the matter is, regardless of the accuracy of her description, it's clear that she suffered mental pain and anguish, which is what our laws permit compensation for in the non-economic form of non-economic damages.
So what's one example of her suffering?
Well, that's one of the examples, is the fact that every time she sees her animal stumble or fail to hold, drool and saliva in his mouth, she's reminded of the pain and the specific trauma that she suffered on the day watching this cat have to get his leg amputated, watching this cat be punched holes in its leg by a deadly
What does that
predator.
result in? The reminding of that, what does it result in for her?
Well, that results in stress, anxiety, mental pain, and suffering. That is, it's a bit of a qualifying, qualitative description under our laws of what non-economic damages entails.
Counsel, don't we have to take into consideration all the other trauma that your client went through at the same period, her divorce, her attempt to commit suicide, as well as the death of her parents? How do you factor that into the, the damages that your client would be requesting?
Yes, well, Judge Ledger, that's why we're only asking for $10,000 in non-economic damages, because all of the mental pain and suffering that that the plaintiff, Jordan Amon, incurred during this time period was only partly due to the severe injuries the defendant caused her cat to suffer. That's why we're not asking for this court to force Ms. Amon to be compensated for the entirety of the pain and suffering she experiences today. Just the amount that the defendant is responsible for, and which is related to the injuries the cat suffered.
Do you believe that the defendant is responsible for the amputation costs? Are you claiming the $7,500 as well for damages?
No, Your Honor, that was not approximately caused by the defendant's conduct. The plaintiff admits today that was a result of letting a cat out and not adequately supervising it later on.
And what about the 21,000, was it?
Yes,
For
the $21,000 in the first visit.
the aftercare of the trap.
Yes, that was under our laws. Economic damages for veterinary bills need to be medically reasonable and necessary.
Even though it was with that fancy, maybe more expensive emergency care, and because you couldn't find a local vet to maybe do the same things, and they had to drive whatever it was to reach the emergency services, were those emergency service costs what you'd be entitled to, or more usual costs if you had gone to a local vet for the same care?
Your Honor, going to an emergency veterinarian under the specific circumstances Sphinx was facing on August 3rd was medically necessary. Sphinx was initially cared for by the Humane Society that Ms. Amon transported him to, and according to the testimony of Ms. Amon, the Humane Society reported that Sphinx the cat was about to go into hypothermia, required significant loss of blood, so that he would require blood transfusions and needed emergency surgery as quickly as possible. If, because of the time in which this accident occurred, and because of the extensive harm Sphinx had suffered, and therefore requiring more advanced care, that $21,000 was eminently necessary. He would have died without it, but for the care he received.
Even if it were necessary, counsel, how do you get past jury instruction 18 that basically caps vet bills at the acquisition or original value of Sphinx?
Can you repeat the last part?
Yeah, how do you get past the original value cap of jury instruction number 18?
Well, from my understanding, there has to be no fair pricing of veterinary care and any medically reasonable care in that specific relation to economic damages for veterinary bills. The $21,000 is an accurate description of what care Sphinx the cat was required to meet his medical needs. And so I'm going to go more to the malicious injury tort we've also brought today. Since we discussed some of the damages already, we'll go to the second claim, for which non-economic damages is permitted to be compensated for under malicious injury. So we'll start with malicious intent. Now, while the legal definition of malice in our jurisdiction is an evil desire to vex, harm, or annoy another, this court is permitted to presume malice where a person acts in willful disregard for a civil duty. While we discussed in the negligence section that the defendant knew she had it, that's why, as to your line of questioning, Judge Coleman, that's why she put out these warnings. Granted, they were ineffective to meet the reasonableness standard to take her out of negligence. And due to the fact that she knew this warning sign was necessary, and that she knew that people would be harmed or animals would be harmed by being lured to her trap by food, the defendant willfully ignored that duty by not acting in accordance with the requirements our society and our laws imposed on her. Because of that, this court may presume, and should presume, that the defendant acted with malice on August 3rd and every day before when she planted this trap and laid out insignificant warnings. And under the doctrine of transferred intent, which should apply in this case, the defendant's willful breach of duty should transfer into a malicious intent to hurt Sphinx the cat, which gets us to the second piece of the malicious element. It's malicious intent to harm a person or animal under our statutory definition of malicious injury. So that goes to malicious intent and transfers to an animal. Next one is proximate cause, which we've been discussing during this case. And like I said earlier, the defendant should have known that her bait would lure Sphinx the cat. She should have known that her warnings would be ineffective. And if she didn't know that, she has imputed knowledge under a reasonable standard of that fact. And she knew that her food was going to lure an animal, and she knew that that would make her trap more dangerous, or at least should have known under a reasonable standard.
I'm sorry, I have a hard time with this notion that baiting the trap somehow made everything worse. I mean, she wanted to catch an animal. She wanted to catch a specific animal. She thought she was baiting it for a dog, that specific dog. That's what the whole thing was about. So, I mean, to catch the dog, you bait your trap. I mean, I think that's fairly standard.
While it may be standard to use food to lure animals onto a trap, the reasonableness standard is defined by the community you're in. The fact, if I may take a moment to answer your question, and
Sure.
then I will
Sorry.
conclude briefly.
Sorry. Yeah.
To finish answering your question, Judge Coleman, the reasonableness standard depends on the community. While it may have been eminently reasonable for someone in a rural part of Cosmopolis to set out this trap and put bait to lure it, that's only reasonable because there's a lesser risk imposed on that person's neighbors. Because Miss Amon and the defendant lived in a residential area on the same street, fairly close to each other, such that Sphinx could sometimes travel over relatively easily to that neighborhood. The defendant had a duty to limit the dangers of her trap, which were increased. Danger is essentially equivalent to the likelihood of harm. It's more likely an animal is going to get harmed by a trap when you're baited to it. And for those reasons, this court should enter a judgment in favor of the plaintiff, Jordan Amon, and enter damages in the total of $35,000. Thank you.
Thank you.